Good morning. Um, there were multiple firm advocates practicing, according to my knowledge, practicing before the Honorable High Court of Judicature was that of King and Patridge and NGR Pesat office, Vaigai Madam office are totally concentrating on issues of labor. That was their social interest to protect the international rights of the labor workmen, so many things. So, if you want to be a politician, if you want to be a good advocate, if you want to command respect with the clients and the society, you must concentrate on labor issues. And you all know the labor cases are being filed either under Industrial Dispute Act and under Provident Fund claim, if insurance claim, all these things are there, then Workmen Compensation Act before the Deputy Commissioner of Labour, if during the course of employment, if any workman. This apart from that, there are multiple issues. The one of the issue, you must understand how the case was dealt by the lower court and counsels appearing before the court, and what was the distinction from referring a matter under 12(3) of the Industrial Dispute Act for general orders, and whether that is applicable to individual or not. All these things have been discussed in this case, but vital ratio was a man who was driving the vehicle was subsequently medically found that he was suffering from color blind. So he wants alternative employment, but that was rejected. He was retired from service. So he approached the labor court, then the single judge directed the authorities to State Transport Authority to give employment, alternative employment, but the division bench of High Court set aside that order, and that is what that resulted to approach. This is C.H. Joseph versus Telangana State Road Transport Corporation. C.H. Joseph, Telangana State Road Transport Corporation. AR 2025, Supreme Court 3679. AR 2025, Supreme Court 3679. On one hand, the state authorities, the politically manned by the Chief Minister and others, are lavishly spending the money for the what we could say voluntary non-fit injury victims, consuming alcohol, dying, stampede death, running behind stars, resulting their death, and on the other hand causes their own workmen to resist up to Supreme Court. But this is because of the standing councils being appointed. All the standing councils think that they want to win the case. Therefore, these things happened. So whatever it may be, the ratio was retirement on declaration as medical fit, denial of alternative employment, colorblind during the routine medical check is declared unfit. So that is without any demonstrable effort by respondent. Corporation to identify or assess feasibility of alternate employment despite appellant having expressed willingness to be reassigning to a non-driving post. Such inactions violated both statutory obligation and administrative fairness. Statutory obligation and administrative fairness should be understood. Then they have also discussed about Service Regulations Act. There was a settlement under Section 12(3) of the Industrial Dispute Act, which specifically provided for alternative employment to drivers declared colorblind with pay protection and continuity of service. Said settlement was binding statutory contract which was valid and enforceable. That is most important. Then they have read out the Transport Act and regulations. Then they say the shall be retired with grant of additional monetary benefit. That's what they say, internal circulars. Then that was the Supreme Court held the internal circle which purported to deny alternative employment to colorblind drivers limited to AMB, alternative additional monetary benefit, were administrative in nature and could not override the binding effect of statutory settlement. So you must concentrate on that issue, which was deeply discussed in paragraph 10, and 18, 20, 21, 22, 23. All these things are there. And then persons with disabilities, with Equal Opportunity, Protection of Rights and Full Participation Act 1 of 1996. So that was discussed. So finally they have directed them to give him employment, and also they have with some other benefit. That was, they say, 25% of arrears of salary, allowance, benefit from date of his termination to the date of reinstatement. It's a very good judgment. Our Justice Maheshwari, who recently intervened with this Karur Stampede case, and heavily command Justice Senthil Kumar, who was given unwarranted comment on the party which is not before him. So all right, go through the judgment, best judgment. Namaskar.